Welcome to the Business Leader Spotlight Show.
I want to welcome everyone to the Business Leader Spotlight Show. This is Randy Van Ittersum, your host for today. Today we have with us John O'Brien, a leading personal injury attorney in Elk Grove, California. He's here today to talk to us about some of the legal issues that you can encounter in a personal injury case. John, welcome to the show.
Thank you, Randy. Good morning.
Good morning. John, tell us a little bit about yourself and about your law firm.
Well, I've been practicing for about 24 years now. I have a personal injury practice in Elk Grove, but our practice really is throughout California. We represent injured individuals in a variety of matters, including car accidents, wrongful death. We do products liability. We just really handle a wide variety of cases involving personal injuries.
Okay, and tell us, why should somebody hire a personal injury attorney?
Well, I get that question a lot as to, well, what do I need you for? Certainly, if it's a significant injury case, you do not want to be handling that on your own. You don't even want to consider that. You will not get fairly compensated from the defendant or the defendant insurer without the advice and assistance of a lawyer. Bigger cases, require everything from start to finish to be considered in the context of how the case will be proven in front of a jury. A layperson is just not really equipped to prepare their case or argue it to an insurer the same way that an attorney is. Now, having said that, some smaller cases, I think it is appropriate to handle them yourself, and I'll evaluate that for someone if it's a small case, and I think that they would be better served taking it to small claims. I walk them through that process, explain how to do it, and explain why they're actually probably better off not hiring an attorney. So we make that initial assessment during the first few minutes of meeting with any prospective client.
Okay. And tell us, in managing a client's expectations, what's the most frequent problem that you encounter in a personal injury case?
I find that people are just not prepared for how long it takes to actually resolve a case. Again, if the case is complex or it's a significant injury, those certainly almost always take longer to resolve than people expect. But in order to do the case correctly and to make sure that they are fully compensated, they have to be patient with the process. The first issue that always comes up is, how long is it going to take the person to recover? Or how long is it going to take for us to have a complete picture of what their future is going to look like? And you can't rush that process. It takes a while for people to get the treatment they need, to get the diagnostic procedures they need, and sometimes it takes a while for the full magnitude of the injury to manifest itself. So that's the first issue that governs, how long is it really going to take for the case to proceed. Until the person is done treating, we don't know how much time they're going to miss from work, what their medical expenses are going to be, and whether they're going to need future care. Those are questions that have to be answered before you can step in and start moving the case forward. After that, cases seem to be settling less and less pre-litigation. Insurance companies have gotten very stingy in the last couple of years and are not dealing with cases fairly before we file the lawsuit. So we used to get a fair number of cases resolved prior to filing lawsuits. Now, unfortunately, and maybe it's the economy, maybe it's just the way the pendulum is swinging right now, but insurance companies seem to be forcing almost all of our cases into litigation. Once the case enters litigation, and by that I mean we've actually sued the responsible parties, then the timing of it is governed by the courts, and it goes through a very definite process of discovery, and then usually a mediation, and then after that, expert discovery, and finally trial. It's still rare for a case to be tried, but many cases go all the way to the courthouse steps, and that is a long process. That's probably the thing that I try to educate my clients about most, is how long the process will take in order to get them fully and fairly compensated.
Great insight. Tell us, if somebody were to come to you for a consultation, what's the process that they could expect to go through?
Well, my consultations usually take about an hour or a little bit more, depending, again, on the complexity of the case and really the questions that the individual client might have. But I like to walk them through the entire process of what they can expect down the road, what discovery will consist of. I want them to understand what it is that we do here, and again, I need to educate them about being patient with the process and letting it unfold the way that it should so that we can get them fully compensated. But I use that hour or hour and a half as really an educational tool, because people come in with certain expectations, just like jurors enter the courtroom with certain expectations, and we spend a lot of time educating them because probably 75 or 80% of what they think a personal injury case is all about, or what a lawyer does, is so fictionalized from TV that they don't really have a good understanding of what's about to happen.
Okay. And tell us, John, everybody wants to know the cost of hiring a personal injury attorney. What can they expect to pay, and who's expected to pay for these costs?
Well, that's the nice thing about the way that it works from the plaintiff side in a personal injury case. All plaintiffs' attorneys work on a contingency fee, meaning that we don't recover anything for the time, the expense, the risk that we take, and all the costs that we advance in the case until it's resolved. So, it's designed that way to give everyone equal access to the courts, whether you can afford it or not. Anyone who is injured and deserves compensation and the defendant is not taking responsibility can have access to, the very best lawyers because they're not paid until they get the case resolved. So most reputable plaintiffs' attorneys also advance all the costs and do not expect to get paid back for any costs that they advance or risk in the case, even if they don't recover, or even if they don't recover enough to cover their costs. So that's why most good plaintiffs' attorneys take a long time looking at the case and making sure that they can win it before they step in, because they know they are ultimately taking the risk with respect to both their time and the costs that they advance in the case. So there's really no downside for a person who is pursuing a case, with the exception that we have to put in all of our fee agreements up front, that in the event that the person, the unlikely event that the person loses at trial, they could be responsible for the other side's costs. Now, in 24 years, I've never had that happen, but we have to tell everyone that when we're explaining the cost and fee structure going in. And the reason that it never happens is there's so many opportunities along the way, if there are some negative issues with the case, that the client can make decisions, all along that, they're never going to be encountering a situation where they're going to have to pay the other side's costs in all likelihood.
Okay, so what I hear you saying is that there's an adversarial position that occurs when you're filing against an insurance company, and the fee structure is such that it's performance-based. In other words, you take the risk rather than the injured party, so it makes it accessible to everybody. And there's really, from what I can see, no reason at all why they wouldn't go and hire a personal injury attorney.
Exactly. So, and I forgot to mention, the standard fees for almost every plaintiff's personal injury attorney are 1/3 before the case is tried, or 40% if the case is tried. And the 40% figure usually kicks in at different times for different attorneys. Everybody has a different opinion as to when it's fair for the fees to go up, but the time and effort that's required to actually try a case is significant, so that's what warrants the difference between the 1/3 and the 40%.
Okay. And let me kind of get into the idea of a case a little bit. And let's say I was injured in an accident, and the insurance company wants me to sign a medical authorization form so that they can kind of see what my injuries are, so they can adjudicate the claim. Should I sign it?
Well, that question is a good one, and what you really need to consider if you're the injured person is, are you going to hire an attorney or not? And again, if you have any kind of significant injury at all, and by that I mean something more than, some aches and pains, maybe a few visits to a doctor or a week or two with a chiropractor. Anything more than that, you should really think strongly about hiring an attorney. If you are going to hire an attorney, don't sign anything to the insurance company. Don't give them any authority to do anything, to look at your case, to inspect your records, to do anything. One of the things that we do when we get the medical records with our client's authorization is we look through them and we call out anything that's private that has nothing to do with the case or their injuries with respect to the case. As you can imagine, when we get a woman's treating records, for example, she might have obstetrical or child care or childbearing issues in her records that have nothing to do with her sore back from the accident. We don't think that a client should waive their right to privacy and give private records to an insurance company which who knows what they'll do with them. So we go through, we make sure they only get the records that are relevant to the case. If a person signs a general authorization to an insurance company to get their records, that insurance company can get any records they feel or they choose, and the person is completely at the insurance company's mercy as to what they can look at and what they can choose to use as relevant in the case. So I always encourage people, if you're going to hire an attorney, don't sign anything. Don't even talk to the opposing insurance company.
Okay, and let's carry that into, rather than sign something, I know I had a situation in the family where they were injured in an accident, and the insurance company actually was in contact with them within hours of the injury and wanted to take a statement saying that they wanted to do that while everything's fresh in their mind and, they got the facts right so they can proceed with their claim. Should you give a statement to the insurance company when they contact you requesting one?
Well, and you just cited a scenario that's very common. And so probably more often than not, when clients come in for their initial consultation, they have already given a statement like that to the opposing insurance company. If they haven't already, I advise them not to. And here's why. If you're talking about like a rear-ender case, something that's really straightforward, people often ask me, well, what's the problem? I'm just telling the truth. I'm just telling them what happened. What difference does it make? The problem is that what insurance companies are doing when they record your statement early on, you've also probably given a statement to the reporting or investigating officer. Later, if the case doesn't resolve, like I said, pre-litigation, now you're giving a deposition, again, sworn testimony about the facts of the accident. And what the insurance company likes is multiple statements out there that they can exploit if you change anything having to do, even with minor facts or minor details that, when you're giving your deposition a year and a half later, you may remember something slightly differently. You're not being dishonest. It's just your memory is not as good as it was, or some things have changed in your mind. You're still being honest, but the insurance company then gets to exploit those differences and argue that you weren't being candid either when you gave the recorded statement, when you gave the statement to the officer, or when you testified in deposition. The more times that you give a statement and have subtle differences in details, the more they get to argue that you're not a credible witness. And so I just don't like giving insurance companies any ammunition if we can avoid it. Normally, if there's a reason to give the opposing insurance company a statement pre-litigation, I'll insist that it be done where it's not recorded so they don't get that advantage. If there's something they need to clear up so that they'll pay the property damage, or they need to clear up because they don't understand how you could have suffered a whiplash or whatever the issue is, I will allow that sometimes, but I never allow it to be recorded.
Okay, and kind of a follow-up to that, would it be fair to say, again, going back to this adversarial position you have with the insurance company, is number one, they have some pretty well-trained people to go out when there's a claim and talk to people. And I know that when attorneys are in a room and saying things, they word things, very carefully. And would it be fair then to say that, the insurance company, I don't want to say that they're being dishonest, but their adjusters are trained to possibly entrap you into saying something that seems very innocent to you, but, could hurt you?
Absolutely. And again, I don't think the insurance company, I agree with you, the insurance company's not doing anything wrong. But the insurance company and their adjusters are acting in the insurance company's best interest, not yours. When it's the opposing insurance company, all they want to do is minimize that check that they have to write at the end of the day. And they'll do anything within the bounds of reason and the law to minimize that. So, asking you the day of, what hurt, and you tell them, and, the next day you have aches and pains all over, because sometimes it takes 24 hours before you really feel the full extent of an auto impact, and then, you didn't tell them about shoulder pain, but you have that bad shoulder pain the next day, then they try and exploit that by arguing later that, well, you didn't have shoulder pain on the day of, you had it the next day after you met with a lawyer or something like that. They just try and, use whatever advantage they can by getting you to say whatever they can get you to say early on and use it against you later if it's to their advantage to do so. That's why in the encounter with the opposing insurance company, you should be viewed as an adversary, and anything they're trying to get from you is so that they can minimize how much it takes to resolve the case.
Excellent. We're nearing the end of our interview, and I have one last question I'd like to ask you, and that is, if somebody is looking for a personal injury attorney, what should they look for, and how should they go about selecting the right attorney for their situation?
That's a good question. I find that people probably get sent to the right attorneys when they go to someone they trust who has personal experience with an attorney and then refers them to that attorney. I think that is a much better way to find quality legal representation than just relying on what's on someone's website or, TV commercial or whatever it is. If you have a trusted professional like an accountant or, a medical professional or, a neighbor down the street, just someone who's had personal experience with their lawyer who highly recommends them because that lawyer, was accessible, communicated with them, and did a great job. That's stuff that you really can't learn truthfully, I think, from a website or from somebody's marketing campaign. Word of mouth is, I think, the best way to find a quality lawyer.
Excellent. John, I want to thank you for sharing your insights with us today. I know that our listeners are going to get a lot out from what shared with us, and it's very much appreciated. If you want to learn more about John O'Brien, you can go to www.johnobrienlaw.com or call 916-714-8200. And again, John, thank you very much.
Hey, it was my pleasure, Randy. Thank you.
Thank you for listening to the Business Leader Spotlight Show.